Hello, this is Matt on the Moon Family Sedan channel. I've got 3 stories to share with you in this latest room temperature jam. And there's this headline: Coinbase could have a better fair notice defense than Ripple. Deaton. That's not quite what Deaton said. I'm going to share with you the specifics that led to this, but honestly, it's kind of more like if Ripple has a good run regarding their fair notice defense, then it could benefit Coinbase. So the headline's not quite precise enough, but setting that aside. Attorney Deaton is also engaging in a new crypto-related endeavor, and he's asking for your help. Look at this headline from the Crypto Basic. Pro XRP lawyer, new campaign sends over 2,000 messages to alert Congress of SEC overreach. And also, by the way, who is a better fighter in the crypto space than Attorney John Deaton? Is there one? Because I don't think the answer is yes. I think he is. Which is why I've said before, if I were Attorney John Deaton, I'd just walk around wearing a cape all day because he has reached superhero status. Also, the SEC has finally filed a response to the supplemental authorities, I think that's what it's called, in the SEC v. Ripple case. So additional cases were cited by Ripple's attorneys, and the SEC's not having it, and they're saying a bunch of hoo-ha nonsense and horse pucky. So I'll let you know what it is. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Oh, and by the way, on top of comments from Attorney John Deaton, I got some stuff from Attorney Jeremy Hogan and Attorney Bill Morgan. So anyway, let's jump into this. So this headline having to do with Coinbase and the fair notice defense, already corrected that, but let's jump into what Attorney Deaton was actually talking about. He tweeted out the following. The SEC versus Coinbase case raises fair notice defense to an even higher level, fair notice 2.0. Judge Torres doesn't reach the fair notice defense unless she finds that Ripple offered/sold XRP as an investment contract at some point, whether during 2013 through 2017 or today. And so let's pause to note, we don't want to get to the point where Judge Torres is ruling on the fair notice defense, because if she's ruling on that, then she did find that there's a problem with something having to do with the way in which XRP was sold. I'm hoping the answer can just be avoided, just zilch. But who knows? Even if that does happen, maybe Ripple can still go forward with the fair notice defense. Maybe there can still be some sort of declaration regarding secondary market sales. So we'll see. But it's not what we as XRP holders would hope would even be addressed. So just know if that's addressed, something's gone wrong for Ripple, and that could potentially be bad for XRP holders. And then Attorney Deaton says, if she agrees with Ripple that a jury must decide whether Ripple received fair notice, or she decides as a matter of law that no reasonable jury could conclude Ripple did, it will mean the crypto fair notice defense has real teeth and Coinbase will be sitting pretty. And so there you go. It's not that Coinbase's fair notice defense is better. It's that there would be something of a precedent effectively set, and Coinbase would be indeed sitting pretty should such a scenario unfold. And then there's this headline from the Crypto Basic. Pro XRP lawyer, new campaign, sends over 2,000 messages to alert Congress of SEC overreach. And he's talking about his latest endeavor having to do with Connect to Congress. And so he's had Connect to Congress live for some time, and he's largely been pushing for certainly people in crypto, but specifically within the XRP community, get the message out, complain to, if you're in the United States, complain to whoever your representative would be based on, wherever you live in the United States. And it's been very successful. But given what's been happening lately, in particular with the push from the SEC against Coinbase, because they's about to get sued. The SEC has publicly stated that. I'm sure all of you have heard at this point. John Deaton decided time for a new campaign to push back even harder and stronger, and he's doing that. And so he tweeted out the following. Actually, here, I can pull this one up first, because here's the initial one from March 23rd. Here he said, go to crypto-law.us, connect to Congress app. I have written a default message that will go directly to each person's 2 senators and representative simply by putting in your address. Tell them you have had enough. It takes 30 seconds. And then he provided the link there. Then he wrote a little update in terms of the participation of this, which is pretty damn impressive because things happened quickly. And so Attorney Deaton wrote, Connect to Congress update. after the response to a single tweet from earlier today, there have been 2,355 messages sent in the new campaign from 785 total advocates, and more than half of those are new people sending their first message ever through the Connect to Congress app. We have reached all 100 Senate offices and 350 House members. The message is already written for you, and it takes 30 seconds. This is how easy it is to have your voices heard. Let them know enough is enough. Yeah, and of course, by the way, you can modify the message if you want to. But the point is, this is a truly organic movement. And I'm telling you, most people never write to Congress ever in their entire lives. And it's just one of those situations where squeaky wheel gets the grease. So even if we're, crypto people interested in crypto, even if it's a small percentage of people, and then an even smaller percentage of those people that are interested in crypto actually do this, I'm telling you, this is what gets attention. You're going to be on the radar. And so the fact that we have this crypto community, including obviously a lot of people in the XRP community, it's highly consequential. Don't think that it isn't. Don't think that your voice doesn't hurt. It's highly consequential. That's just how these things work. Squeaky wheel gets the grease. Damn it. Then we've got this. So SEC v. Ripple. SEC finally responds to Ripple letters of supplemental authority. And so we found out this yesterday afternoon. Here you have the news from attorney James Filan of the XRP community. He wrote, the SEC has filed its response to the Ripple defendants' letters regarding supplemental authority from the Bittner and Voyager cases. And I've already covered those cases in pretty great detail, so I'm going to stay outside of that for the purposes of this video. But it's just to understand that it's rulings, previous cases that Ripple believes firmly, and for good reason, would be impactful regarding Judge Torres' decision in the SEC v. Ripple case. That's what those two cases are about. And so after retweeting that, attorney Jeremy Hogan took a gander at this, and he retweeted that, and he wrote the following. The SEC finally replies to Ripple's supplemental authority. They must be busy with other things. Yeah, and so, by the way, I'll just pause. I was questioning that, too. I was like, and I wasn't the only one, but where's the response? Do they just not care anymore? And then attorney Hogan says, although it raises valid points, re the Bittner case, its attempt to argue that the Voyager judge did not say that the crypto space faces glaring uncertainty is smirkable, smiley face. I think these are two cases that are bad for the SEC, and this reply negates the Bittner decision a little, but doesn't take away much bite from the Voyager judge's ruling. But it's all fair notice defense stuff. Yeah, and fair enough, because if we get to this point, it's like something went wrong. So let's hope we don't see that. Attorney John Deaton retweeted that from attorney Hogan and wrote, not that XRP holders want to go to the Supreme Court, but let's not forget the language favorable to Ripple's fair notice defense in Bittner came from Judge Gorsuch, who used to work under Michael Kellogg at Kellogg's firm, who orchestrated Ripple's fair notice defense in brief. Yeah, and he broke that little tidbit information, which I hadn't heard until he broke it on during an interview with Eleanor Terrett, Fox Business Network journalist. And so I guess it was a couple days ago, he dropped that. I was like, that's an interesting connection there. And then we also have this. Eleanor Terrett, Fox Business journalist, retweeted that from attorney Filan and shared a little snippet which reads as follows. So this is from the SEC. Defendants shamelessly mischaracterize the Voyager bankruptcy court's statements and pluck choice phrases out of context in a misguided attempt to boost their unavailing fair notice defense. End quote. Okay. Well, that's nonsense, but even if that were accurate, Judge Torres has the actual rulings and can and undoubtedly will read all of it. She will know. But of course, it's just the asshats at the SEC. And then attorney John Deaton responded referencing Jorge Tenrero, who is one of the SEC attorneys on this case, and he wrote, Jorge using the word shamelessly to describe anyone other than himself or his fellow SEC colleagues is cute. Oh, yes, it's absolutely adorable. All right. And then you have this from attorney Bill Morgan. So he retweeted that as well and said, check out the last paragraph. The SEC refers to direct Ripple sales to public investors. Have not seen it put its case that way before. All Ripple sales since May 2020 are to on-demand liquidity customers who are not investors because they immediately use it for transfers, not for investment. Yeah, and I've not seen this before, and other people in the community pick this up. It's on the screen. I don't feel the need to read it, but they did indeed talk about XRP sales to public investors. I don't recall ever seeing that anywhere before. Unless I'm forgetting something, I don't recall ever seeing that. Because it's been all about just the vagueness of every single thing, the embodiment theory. Every single thing that XRP touches in the land is a securities violation. That's basically it. The embodiment theory. It embodies the security and all the promises from Ripple, all that crap. But now they're talking about specific XRP sales to public investors. Where? They've literally never done that. That much I know. I don't know. You guys let me know what you think. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.